Judge, I have just one brief issue. I don't know if Mr. Turbin's going to testify today, but when he proffered his testimony last week, he made a statement that Grant has a history of stealing. I would just ask that he not say that.
That would be excluded.
Yes,
I'll remind you.
And you can instruct him of that.
Yes, ma'am.
All right. Other than that, you said the witnesses are present. If we could please have them brought into the courtroom. Who's your first witness?
Investigator Blay.
Okay, so have Investigator Blay brought in, and then you can get the jury. Good morning, everyone. Hope everyone had a good weekend, and everyone stayed, of course, away from the news. At this point, the state's still continuing their case, so the state may call their next witness.
Investigator Blay.
Raise your right hand.
I solemnly swear or affirm that the testimony you're about to give will be the complete truth, so help you God.
I did.
Thank you.
You may proceed.
Thank you. Good morning.
Good morning.
Can you please introduce yourself to the jury and spell your name for the court reporter?
Good morning. My name is Geraldine Blay, B-L-A-Y.
And where do you currently work?
I am a deputy sheriff at the Seminole County Sheriff's Office
And how long have you been at the sheriff's office?
since April 2014.
Now, you're a sworn law enforcement officer,
I am.
certified.
Yes, I am.
Do you have any education besides the police academy?
I do.
Can you please tell the jury your background and education that's not police academy related?
Yes. I have a bachelor's degree in general science with minors in mathematics and computer science from the University of Puerto Rico. I also have a master's degree in digital forensics from the University of Central Florida.
And now can you tell us about the training that you had to complete in order to become a law enforcement officer?
Yes, I attended 770 hours of the Law Enforcement Academy at Seminole State College.
And what are your current assignments at the sheriff's office?
I am assigned as an investigator in our digital forensics unit.
And when were you first assigned to the digital forensics unit?
September 2016.
And you said digital forensics. Are you a digital forensics examiner?
I am.
And what are the duties of a digital forensics examiner?
So we investigate and analyze all, different kinds of electronic devices, such as cell phones, hard drives, thumb drives, even infotainment systems in cars.
Now, can you tell the jury the training that you've had to complete in order to handle and examine computer devices?
Yes. As far as certifications, I am a CFC, which stands for Certified Forensic Computer Examiner. Certified Computer Forensic Examiner. From IASIS, which IASIS means International Association of Computer Investigative Specialists. I also have the COFFEE certification, which stands for Certified Advanced Windows Forensic Examiner, also from IASIS. As far as I am also an ENC, which stands for NCASE Certified Examiner. As far as cell phones, I have the Celebrite CCO and CCPA, which stands for Celebrite Certified Operator and Celebrite Certified Physical Analyst. I am a BERLA IV Certified Examiner for Vehicle Forensics. Some of the classes that I have taken are the BCFE, Basic Computer Forensic Examiner, Windows Forensic Examiner, and Advanced Macintosh Forensic Examiner from IASIS. From the National Computer Forensics Institute, I have taken Advanced Forensics Techniques. As far as NCASE, which is a software that we use, I have taken Digital Forensics 1 and 2, Advanced Internet Examinations of NTFS file systems, incident investigations, Macintosh examinations, among others.
That's a lot of training. How many hours is that?
Over 500 hours.
Now, have you coached any classes relating to computer forensics?
I do.
And can you tell the jury just briefly what it means to be a coach in the context of a forensic examiner?
Yes. For the CFC, for the Certified Forensic Computer Examiner process, each student that goes through the certification has to complete 4 problems, 4 practical problems. So each student gets assigned a coach, which is in charge of reviewing their problems, making sure they get it perfect. And if they are struggling with an area, we coach them, we guide them. We don't tell them the answer. We teach them a little bit of how to get the answer, how to get there by themselves.
Are you the member of any professional organizations in this field?
I am.
Would you tell the jury?
Yes. I am a member of the National Computer Forensic Institute's Technical Advisory Council, and I am also a member of IASIS, International Association of Computer Investigative Specialists.
Have you received any awards or honors with regard to the work you've completed?
I did. In June 2019, we received the Sheriff's Commendation for a case we were working on.
Now, how many forensic examinations have you conducted on various devices?
I have conducted over 300 examinations on over 1,000 devices, and I have assisted in others more.
Okay, so let's shift gears a little bit. I want to ask you some questions about computers, okay? Can you tell the jury, basically, the components that make up a desktop?
Well, this depends, because there are different kinds of desktop computers. But in general, it would be the monitor, the box, and some peripherals like a keyboard, a mouse, a printer, depending on the user.
So the monitor is the TV.
Yeah.
And the box, what's in the box?
That also depends. But the CPU, RAM, some non-volatile storage, so like a hard drive or a solid-state drive, some expansion cards like a graphics card. So it depends.
Okay, and can you, in very general terms, which I know is difficult in your field, tell the jury how a file is stored on a hard drive?
Okay, so just like he said, we could talk about this all day, but in general, when, say, you're using the Notepad application and you're typing a document, that is stored in RAM, which is the volatile memory. It's stored there because it's faster to access. When you're done with the document, the operating system then saves it to the hard drive or solid-state drive. I like to compare it with a kitchen, for example. Say I'm going to cook a recipe. I get whatever ingredients I need. I get it out of the fridge and I put them on the countertop. The countertop is like RAM. It's everything's there, accessible and like easy to use, easy to get. But when I'm done, I have to put everything back in the fridge. So I mean, it would be awesome if I could just leave it on the countertop so I don't have to go back to the fridge again. But I can't because I'm going to need that space, that counter space for my next recipe. So that's how I like to compare it.
Okay, all right. So maybe the countertop is like when a husband is cooking dinner for his wife. It's a big mess.
Okay.
All right. Now, with regard to your computer forensic duties, do you ever actually work on the particular piece of evidence that's recovered from a crime scene?
No, we do not.
Okay. What do you make in order to conduct an examination of a hard drive or a phone or whatever?
So we make an image, so a forensic copy, pretty much.
Okay, and what's a forensic image?
It is a bit-by-bit copy of everything in the storage, in the hard drive or the software, or the SD solid-state drive, or the thumb drive. It includes like deleted stuff, blank spaces, everything pretty much.
So it's an exact digital copy of the original piece of evidence?
It is, yes.
Every single bit?
Yes, everything.
Now, how do we know that it's an exact copy?
Well, we calculate what's called the hash value of the copy, and we compare it to the hash value of the original, and if they match, it is an exact copy.
Okay. And how do you ensure that while you're conducting your examination of this copy, that nothing gets written to the original?
So when we are creating the image, we connect it to a write blocker. A write blocker, I like to think about it. Write blocker is software that lets you read from the media, but it doesn't let you write to the media or make any changes. I like to think about it, it's like a kind of an old analogy, but like when you had the old VHS tapes or the cassette tapes, they would have like a plastic tab that you would break off, and then you wouldn't be able to write to it. So that's what I like to do.
Okay, so it's a little more complicated than plastic tab, but the idea is the same.
Yes, the same
Okay.
principle.
All right, now I want to sort of shift gears a little bit and talk about some of the work you did in this particular case, all right? Now, you described the basic steps of what you do. You make a copy of it, you ensure that the copy is an exact copy of the original, and then you have a variety of tools you use, is that so?
Yes, that is
Can you
correct.
tell us some of the tools you use to conduct an exam?
Yes, of course. I use Encase, Blacklight, Axiom, Physical Analyzer, and some hardware tools too, such as Gray Key or the UFED Touch too.
Okay, and are those tools that are used and standardized in your particular field of expertise?
They are.
Okay. Now, I want to draw, like I said, your attention to the work of this particular case. Did you do forensic work on a variety of items in this particular case?
I did.
Okay. I want to show you some photographs of the various items you worked on. And for the record, I'm showing defense counsel exhibits 9I, 8S, and 9A. May I approach the witness? Ms. Bly, I'm going to start by showing you what's been marked for identification purposes as State's Exhibit 8S. Do you recognize what's contained in that image?
I do.
And what is it that we're looking at?
It is a picture of the computer setup in Grant's room and item N7.
Okay, item N7, that's your speak.
It is a computer tower.
Okay. I'm also showing you Exhibit 9I for identification purposes. Do you recognize this?
I do.
And what is this?
It is a paper printout of a laptop computer that I examined.
Okay. And I'm showing you Exhibit 9A. Do you recognize that?
I do.
And can you tell us what this is?
It is a paper printout of the thumb drive, one of the thumb drives that I examined.
And these photos, 9A, 9I, and 8S, are they fair and accurate depictions of the items they contain?
They are.
Judge, we tender these into evidence of the state's next.
Any objection?
No objection.
All right, what's been pre-marked for ID as State's Exhibit 8S will be moved into evidence as State's Exhibit 206? Oh, 231, where are we? Where's my number chart? Okay, 231 in evidence. What's been pre-marked for ID as State's Exhibit 9A will be moved into evidence as State's Exhibit 232 in evidence. What's been pre-marked for ID as State's Exhibit 9I will be moved into evidence as State's Exhibit 233.
Permission to publish?
You may.
Now, Investigator Bly, you have identified these photographs. I'm just going to go through them real quick here. I'm showing you on the overhead what's been marked into evidence of the state's 231. So now on your screen there should be a little arrow with a mouse, a little pop-out arrow. Mm-hmm. If you click that pop-out arrow, and I think the judge actually may set you up for that. Okay, great. So can you use that little pointer that you have in front of you to show us the actual tower, the box that you worked on in this case? Right there? Okay, and you said that was located in Grant's room, you said?
It was.
Okay. I'm showing you Exhibit 232.
Oh, how did I get rid of that?
Arrow to the right, up at the top, that little arrow. Click on the arrow. Go all the way down to clear. Press clear. Okay, now if you want to mark again.
And Exhibit 232, is this an item that you examined?
It is.
And just real quick, what is it we're looking at here?
It is an A-Data thumb drive, a 32 gig thumb drive.
Okay, so the little flash drive. And do you know where that was located?
Yes, it was located in a pair of pants.
I'm showing you Exhibit 233. What are we looking at here?
The laptop that I worked on, Margaret's work laptop.
Okay. May I approach the witness? For the record, I'm showing defense counsel exhibit 8N as in Nancy, 6O, and double K. May I approach the witness? Get gloves up here.
It do. Look at this.
Okay, for the record, I'm showing you item 8N. Do you recognize this?
I do.
How do you recognize it?
It has my handwriting in the front part of the envelope, and it also has my signature, like my initials and the date on the back of the envelope.
Okay, and is that packaging in the same or substantially similar condition as it was when you first reviewed the item?
Yes, it is.
And what's contained in that package?
The four of the thumb drives that I examined.
And would you mind opening the envelope, please? Of course. Take a look and let's make sure. Everything's good?
And yes, sir.
Judge, we tender exhibit 8N as states next.
Drive. No objection.
March Friday, State's Exhibit 8N will be moved into evidence as State's Exhibit 234 in evidence.
Permission to publish?
You may.
Are these in fact the portable thumb drives that you examined?
They are.
And the one on the very top, that's the one that was in that photograph we just displayed?
Yes.
Now, Investigator Blay, in front of you, you have State's Exhibit double K for identification purposes. Do you recognize that item?
What do we?
Double K.
Oh. Yes, I do.
How do you recognize it?
It has my handwriting in the front part of the bag, and on the red tape, there's my initials and the date.
And is that package in similar or substantially similar condition as it was when you first reviewed the item?
It is.
And what's contained in that package?
The laptop that I worked on, Margaret's laptop.
Would you mind opening the bag? Laptop?
It is.
Okay. We tender double K as states next.
We'd object on the grounds of our prior motion, Judge.
As to double K, what's been pre-marked for ID as State's Exhibit double K will be moved into evidence as State's Exhibit 235 in evidence. An objection will be overruled.
Permission to publish?
You may.
has been marked for identification purposes as 6O. Do you recognize this?
I do.
How do you recognize it?
It has my initials and the date on some of the red tape on it.
And is it in substantially the same condition as it was when you first reviewed it?
Yes, it is.
And what is contained in this exhibit?
It is an Apple iPhone.
Would you open it back, please?
Of course.
Is the iPhone you examined?
It is.
We tender 6O as states next.
Only on the grounds for a prior motion, Judge, so we would put that objection on the record.
All right. Objection overruled. As to what's been pre-marked for ID, State's Exhibit 6O will be moved into evidence as State's Exhibit 236 in evidence.
Permission to publish?
You may.
I want to ask you, in addition to your duties as a digital forensics examiner, did you aid in searching the residence in the surrounding area of 2112 Sultan Circle?
I did.
And besides the forensic examiner, are you also a canine handler?
I am.
And what kind of canine do you work with?
I have an electronic detection canine
And how long have you had that canine?
since November 2017.
And can you tell the jury, we know what a canine is, but what's an electronic detection canine?
Well, just like some dogs detect drugs or detect bombs or cadavers. Electronic detection canines are trained to detect the TPPO in electronic devices.
What's TPPO?
TPPO stands for triphenylphosphine oxide, which is a chemical that is used to coat electronic devices just to help with the cooling.
So it prevents them from overheating?
Yes.
And how long was the training you had with, what's your dog's name?
Siri Cinnamon Bark.
How long was your training with Siri Cinnamon Bark?
She was trained for 5 to 6 months, and then I went to the handler course for 2 weeks, and then there's like a 6-week acclimation, getting used to each other period before we start getting deployed.
And have you gone through any additional training with Siri?
Yes, we have to go through training and recertification at least once per calendar year. So I recertified in November 2018 and in May 2019.
And how often do you train with Siri?
Well, like some of the dogs that some of the detection dogs, they work based on toy reward. So like if they find something, you give them the toy, and then that's their reward. Siri, it works based on food reward. So what that means is that the only way that she eats is when she's training. So, and she's a lab. She eats just as much as every dog or more. So we have to train every day, twice a day, at least twice a day, no matter if we have a search or not. So 365 days a year, 7 days a week.
So the dog doesn't eat unless the dog is getting trained?
Yes, so
Okay.
she trains.
How many deployments have you had with Siri?
Over 50.
And how about training deployments, like practice? Ballpark.
Well, I've had her since November 2017, twice a day at least, sometimes more.
I'm not a mathematics person. A lot,
A
right?
lot.
Okay. Now, has she ever missed a device in training?
No,
Did you have the opportunity to deploy the canine Siri in this particular case?
yes, I did.
Can you tell the jury how you deployed Siri?
I deployed her around the outside area of the residence and also in the gym area.
And were you able, I should say, was Siri able to locate any other digital devices other than what was visibly found in the residence?
No,
So nothing in the yard?
no.
Okay. Okay. Now, let's begin with Grant's computer, the one you said was in Grant's room, the computer in Grant's room. I'm showing defense counsel 8T, 8U, 8V, 8W, 8X for identification purposes. showing you, for identification purposes, what's been marked as 8T, 8U, 8V, 8W, and 8X. Do you recognize these items?
I do.
And what are these items? What do they purport to be here?
A computer and a solid-state drive that was found inside the computer.
And are these photographs that were taken of that computer in your laboratory?
Yes. They are.
Are they fair and accurate depiction of the items that are contained in them?
Yes.
We tender 8T through 8X as states next.
Any objection?
No objection, Judge.
What's been pre-marked for ID as State's Exhibit 8T will be moved into evidence as State's Exhibit 237 and evidence. What's been pre-marked for ID as State's Exhibit 8U will be moved into evidence as State's Exhibit 238 and evidence. What's been pre-marked for ID as State's Exhibit 8V as in Victor will be moved into evidence as State's Exhibit 239 and evidence. And what's been pre-marked for ID as State's Exhibit 8W will be moved into evidence as State's Exhibit 240 and evidence. And what's been pre-marked for ID as State's Exhibit 8X will be moved into evidence as State's Exhibit 241 in evidence.
Now, investigator, do you and your team, normally photograph items that you're doing forensic examinations are?
We do.
What's the purpose behind that?
Just to document the condition of it.
Permission to publish? For the record, I'm showing you State's Exhibit 237. And that's a photograph. Is that a photograph of the computer you located in Grant's room?
Yes.
238. What is this?
The side of the computer.
239.
That is the main drive where the main drive where the operating system was.
Okay, so that side thing pops out.
It does. Each of those pop out, and there's a drive on it.
Okay. 240.
Same, but
That's-
another view of the same drive.
Hard drive.
Solid state drive.
241.
The back part of it.
Okay, thank you. Now, can you tell the jury what was done with that particular item?
Yes. After we photographed the computer and all of the drives that were in it, and we documented the condition of these drives, for each of the drives we connected them to the write blocker of our forensic machine, and we used Encase, which is one of the software that we use to make an image file, like an image of each of the drives. Then after the image was completed, we calculated the hash values of the image and then compared them to the hash values of the original. Once they match, we put the original away, and we also checked BIOS, so like the system settings pretty much, just to make sure the time was accurate.
Okay, now, during the course of your investigation, were you able to identify if there were any user accounts on that particular item?
Yes, I did.
I'm showing defense counsel 8Y for identification purposes. May I approach the witness? I'm showing you what's been pre-marked for identification as 8Y. Do you recognize this?
I do.
How do you recognize it?
It has my initials and the date on the bottom part.
And what does this document purport to be?
It is a subsection of my Encase report showing user accounts.
And it is a fair and accurate depiction of that section of your report?
It is.
We tender 8Y as states next.
Any objection?
Or prior motion, Judge.
All right, objection overruled. What's been pre-marked for ID is State's Exhibit 8Y will be moved into evidence as State's Exhibit 242 in evidence.
Permission to publish?
You may.
Now, can you explain to the jury what this document shows?
Yes, it shows a list of the user accounts that I was able to find in that computer, in the tower that you guys saw pictures of, and some of the accounts are the default accounts that a computer comes with, but then this account right here, Light, and this is the path, the path where the operating system was installed, like the path for the user directory for that computer.
So does this document show that a username on this particular device was Light?
Yes.
Okay, Okay, now, aside from identifying the user account on this computer, were you able to locate any activity on this particular device between January 24th and January 25th of 2019?
Yes, I did.
Okay, and can you tell us what was one of the first things that you...
Okay. Yes, I found that a thumb drive, an AData thumb drive, was connected to the computer under the user account light on January 24th, 2019 at 11:32 p.m. And then it was disconnected on January 25th, 2019 at 12:27 a.m.
And I'm showing you Exhibit 232. Is that the thumb drive you're talking about?
Yes,
Now, there were 3 other drives in the state's exhibit with the thumb drives. Did you conduct examinations on those drives as well?
I did.
Did you find anything of forensic value on those drives?
No, I did not.
Now, how do we know that this particular thumb drive was plugged into that particular box?
By looking at the Windows event logs and at the registry.
And briefly and simply, what are event logs in the Windows registry?
So event logs are a diary that the computer and some applications use to keep track of important hardware or software events in a computer.
I'm showing Counsel 8Z for identification purposes. May I first a witness? Judge?
You may.
I'm showing you States 8Z for identification purposes. Do you recognize this item?
I do.
How do you recognize it?
It has my initials and the date on the bottom left corner.
And what is this item? What is this?
It is a subsection of my report showing event logs for that computer.
Is it a fair and accurate depiction of that section of your report?
It is.
Would tender 8Z states next.
Object on our prior motion, Judge.
All right, objection overruled. What's been pre-marked for ID as State's Exhibit 8C will be moved into evidence as State's Exhibit 243 in evidence.
Permission to publish.
You may.
Investigator Blay, I want to make sure that what you say is backed up by what you saw. So is this the report that shows the time that that particular drive, that thumb drive, was plugged in?
Yes, it is. Yes.
And when was that?
It was on January 24, 2019 at 38 p.m.
And this was information you pulled off of the logs and registry from Windows?
Yes, that is correct.
So nobody can easily get to that information?
Yes, that is system generated.
Okay. And as far as when it was removed?
January 25th, 2019 at 12:27:37, or around that time. It takes a few seconds to update, to write stuff.
Okay. Now, with regard to additional items that you discovered happening on Grant's computer, did you have the occasion to review whether a particular phone was plugged into that computer?
I did.
And can you tell the jury about that?
Yes. On January 24th, 2019 at 11:39 p.m., an iPhone was connected to the computer. According to the ASL log, that's a log that Apple keeps on a computer. It wasn't able to. They didn't find the lockdown file, which means it wasn't able. If you're an iPhone user, you have to, and you could plug in your phone to a computer. You have to trust it by putting your password. So it wasn't able to do that connection. And then at 11:42, it was placed in recovery mode and connected to the computer.
Okay, so in the late evening hours of the 24th, an iPhone was plugged into Grant's computer. And set up for recovery mode.
It was.
Okay, what's recovery mode?
Recovery mode is a way for an iPhone or an iOS device to connect to iTunes without having to boot, for like pretty much to restore it or to update the phone.
Now, were you able to determine what particular iPhone was plugged into Grant's computer?
I did.
And how were you able to determine that?
While examining the computer, one of the computers in Cody's room, I found a backup of that same phone, and I extracted that backup. It was an old backup. I extracted that backup, and I used Physical Analyzer to generate a report for that particular phone. And I compared the serial number and the UDID, the unique identifier for the phone, with the one that had been connected to the computer.
I'm showing counsel for the defense States Exhibit 14Y and 14Z.
This was our most recent discovery, right?
Yeah. May I approach the witness?
We do now. You may.
Let's begin with States Exhibit 14Y. Do you recognize 14Y?
I do.
How do you recognize it?
It has my initials and the date on it.
And what does item 14Y purport to be?
It is the first page of that report that I made of the backup, having containing some identifying information for the phone.
I'm showing you States Exhibit 14Z. Do you recognize that item?
I do.
How do you recognize it?
It has my initials and the date on the bottom part of it.
And what does item 14Z purport to be?
It shows the iPhone connections made on the made to the computer from the Windows Registry.
Are they fair and accurate depictions of those sections of your report?
They are.
Tender 14Y and 14Z as states next.
Judge, may I approach?
You may. Members of the jury, the state and the defense and I have a few things to go over that we're going to have to do outside your presence. If you could, we're going to take a brief recess. You may be seated. All right. So first, let me ask, what date did the defense receive it?
Judge, I have to just open my email real quick.
All right. Let me know.
Judge, we actually got the extraction report document.
It's the iPhone one, the 14Z that you were referring to.
Right.
Both documents were sent on July 26th.
July 26th?
I think that's correct, Judge.
Thursday.
Thursday. The last email I opened up was from Thursday.
26th is Friday.
25th? Excuse me. That Thursday, last Thursday. 25th.
Okay.
I better wrong. I'm sorry. July 25th.
All right, July 25th. All right. Now, Mr. Leo, please tell me as far as the nature and the circumstances of why it was disclosed on July 25th.
Well, I was sitting in my office, or might have been at home, and I got an email from Investigator Blay saying, hey, I was going back through everything, and I noticed this as well, and it shows what it shows. What do you think? And I said, I think it's interesting and relevant. And as soon as I got the copies of the extraction report and the printout from her forensic tool, I immediately emailed defense counsel a copy of it to both Mr. Dowdy and Mr. Shapiro. I also did a supplemental pleading, I believe on the same date, indicating that I had emailed that to them.
All right. Was there any offering as far as any type of questioning or speaking prior to today?
When I spoke to Mr. Dowdy on Thursday or Friday of last week and specifically explained to Mr. Dowdy what those documents contained and what evidence I intended to use from those documents, he thanked me for being forthright with him, and after that there were no further discussions.
All right. The documents themselves, what do you anticipate that she's going to testify to?
She's going to testify to that the unique identifying number on the extraction report and the unique identifying number on the forensic examining report are the same, that number belongs to Cody Amato's cell phone. And she's going to testify that that phone was plugged into Grant's computer. I don't have the paper in front of me for the exact time, but same time frame, late in the evening on the 24th. And she'll explain, which she already kind of did, the reason why someone puts a iPhone into recovery mode and plugs it into a computer. And I had told Mr. Dowdy pretty much exactly that on last week.
And any particular reason why it wasn't disclosed beforehand?
I didn't know it existed, and I don't want to speak for Ms. Blay, but I don't believe she knew it existed either. And of course, Judge, all the digital stuff has been sitting over there, and I know they went over for an evidence viewing a number of, might have been a month or so, maybe 2 months ago, a month ago, and anything, obviously, that the defense wanted to look at would be made available to them.
And when you say it was a month ago that they went over there, were these documents sitting within that?
Not these documents, no, ma'am. The documents themselves didn't exist until Thursday.
Okay. And what was it then you're saying that was available for inspection a month ago?
The actual hard drives for their expert, if they had one, to review, to go through all the logs and registry data on the hard drives, which is how she found this, was going through line by line by line of all the registry information.
All right, Mr. Shapiro?
Judge, I would just argue that this is late, it's past the jury being sworn. We're prejudiced in that we didn't have this information just in case we wanted to go over additional information in jury selection about any possible issue that may have any relationship to this whatsoever, our opening statements, and additional prep from there. I mean, I understand, we got late stuff from like July 11th, which was like the Blake Turpin arrest report, that was before jury selection. And I understood that, and that's not a problem. This is all after the jury's been sworn, after doing jury selection, and already most of the week into trial last week.
Did you all have an opportunity to examine all the computer hard drives and forensics yourself?
We did, but we also had an opportunity to depose Investigator Blay, which we did so, and we had asked her what she performed, and when we asked her, obviously she hadn't done this yet, so we took the opportunity to ask the lead digital forensics person what she had performed, and we didn't have an opportunity to ask about this because she hadn't done it yet, and then decided to, I guess, go back during trial to check it out, and that's why we were unable to find out this information.
When was it performed?
The deposition of Blay. Oh, Judge, I have it in my email, actually. July 9th.
Done differently?
If I had before trial, I definitely would have added to our deposition questioning about how this all works with regard to when it's plugged into the computer, what your recovery mode means, what that whole action, what her interpretation of the report would mean, practically speaking. That information was provided last week. I know Mr. Leo did describe practically what it means, but it was described last week when we got the notice that it existed. And I may have addressed it in my opening, Judge.
Mr. Leo, anything else that you want to tell the court?
Ms. Bly's been available for deposition the entire time. If they'd like to depose her now, they certainly can. Exclusion of the evidence is the most severe penalty, Judge, and I don't believe that, given the nature of the disclosure and the facts that surrounded how this information came to be discovered, that exclusion is the appropriate remedy.
Was there any request to question Ms. Blay before today at all?
Not to my knowledge.
Mr. Shapiro?
No, I'm not really sure when that would have been possible, but maybe we were just assuming a lack. I don't know when that would have been able to.
Based upon the circumstances in Richardson and other case law, even after, one particularly I believe was Jules versus State that I reviewed. First of all, from what I gather from the facts, the information was obtained, or the extraction report and iPhone report was for March 14, Y and 14Z, but specifically the issue is 14Z, was turned over on Thursday. There wasn't any request or indication by the defense in order to request for a deposition or otherwise. I will state the court has to find that the violation was willful by the state. As soon as they ended up finding out about it, they ended up disclosing it to the defense. Even the defense indicated that based upon the circumstances. In addition, the computer itself and all the information. Oh, I'm so sorry. I didn't even know that you weren't here.
Oh, sorry.
Okay, well then I have to start all over, Peter.
Sorry, Judge.
No problem. That was also my fault, sir. All right. The court has to find, based upon the discovery violation, getting past the first part, whether or not it was willful. The indication that the court has is this information was discovered on Thursday for 14Y and or 14Z, I'm sorry, for the iPhone report. As soon as it was discovered from both parties, it seems to be indicated that the state disclosed what it was, what the information was about. Further, the court notes that there was the opportunity for the defense to do their own examination a month ago of the entire computer itself if it chose to. Whether or not that the report that was initiated afterwards, if they chose to have their own expert or otherwise examine it, they would have the opportunity. But the court notes that the examination or the disclosure of this was not something that was not willful or that was willful by the state. In fact, not willful because of the fact that they immediately disclosed it once it was received. Also, the court notes, in reading briefly again some the case law regarding it, the aspect for circumstances on whether or not it was if there was a discovery violation, whether or not it would be prejudicial or not to the defense. The court noted the three things that were listed was one in regards to the possible questioning during voir dire. However, the computer forensic expert had already been disclosed previously. There's several issues regarding the computers that's already been noted in this trial, whether it be the thumb drive, the dad's iPhone, the laptop or iPads or things of that nature. And none of the specifics were questioned in voir dire because they're prevented from being questioned about in voir dire, which also would make this also being prevented from being questioned about in that sense during voir dire. So that aspect, it does not necessarily make sense to the court. The other aspect, as far as mentioning an opening statement's not evidence. I do understand that that may have been a possibility, but opening statement is not evidence. So then it comes down to also the questioning. The court finds it very finds the fact that the circumstances on which the defendant and the defense chooses to make any objection or even have this brought to the court's attention is during the witness's testimony rather than on Thursday where the court could have ordered a deposition or questioning or otherwise, which is what the case law favors. We did have time Friday afternoon as well, or even questioning as far as the witness as well. In that sense, to even during a case, to continue a case for possibly a day for questioning or deposition if it's needed. And none of that was done in this instance. However, I don't even get past the first part to indicate that it was not willful. That it was willful, and indicates that it wasn't willful. It was something that was done and disclosed immediately. And that would be the first step for the Richardson portion of the discovery violation. Since I do not get past that, the rest of it doesn't even go further. However, the court does comment as to the prejudice of it. Based upon the three items that were indicated, the court wouldn't believe that there would be prejudice either because this could have been questioned or otherwise at the time during the Friday afternoon after when we broke early briefly, or otherwise, or at least brought to the court's attention prior to. The exclusion of evidence is the ultimate sanction that the courts discourage. And also, but based upon the circumstances as stated, it's not willful, and otherwise, therefore, there would not be a Richardson violation. So the court's going to allow the questioning to move forward. If you wish, though, we can take a brief recess, and Mr. Shapiro, and you can, I will have Ms. Blay come down from the stand. You all can, the state and the defense can go outside. They can question her at this time before she gets back on the stand, and the court will allow a brief so-called deposition, so to speak, for purposes of the defense.
That would be great, thanks, Judge.
Okay, so at this point, Ms. Blay, you are free to step down from the stand. If you all want to, you can go into the conference room or one of those conference rooms. I would also ask Peter if you could go out there too, so it's also recorded for purposes of the deposition, and have a brief deposition by the defense of the expert at this time, and we'll take a brief recess. And just let the deputies know when you're done.